Hello and welcome to Coveyor Pod. I'm Lisa Brindle, Head of Learning at Coveyor, and I'm delighted to be your host today. So, in this episode, we're going to be talking to you about sickness absence. We'll be raising awareness of the fantastic services that are available through DAS, including the use of the DAS helpline. And together, we're going to be sharing with you the collective knowledge and expertise from our fabulous panel that I have with me today. So joining me today, we have our very own from Coveyor, Joanne King, who is our head of HR and partnering. And we also have, for the wider external viewpoint, we have Simon Roberts and we have Kath Kidd from DAS Law. So Jo, can I just come to you first of all to introduce yourself to the audience?
You can, yes. So, yeah, I'm Joanne King. So I'm head of business partnering and culture at Coveyor Insurance.
Okay, Simon, over to you. If you can share your introduction and give us also a little bit of a brief overview about DAS, that would be really helpful.
Sure, no problem. Hi, everyone. I'm Simon Roberts, and I'm a solicitor at DAS Law. And DAS Group is a part insurer, part law firm, and all Coveyor policyholders can, if they take out the appropriate cover, can access our services. The insurance is there in the event that you are involved in an unexpected and unplanned legal event. So if, for example, an employee takes action against you or a contractor, then we hope that our cover would provide appropriate representation and resolve the matter for you. We also have a number of helpline services that are there at the event that your issue arises, so you can call us for 24/7 legal advice to help you navigate through a legal problem, hopefully to resolution. But other helpline services out there are for tax and also for counselling.
Excellent, thank you. And last but not least, can I pass over now to Kath?
Hello, everybody. So I'm Kath Kidd. I'm a solicitor in DAS Law's employment team. I've been doing the job for about 20 years now, so I've pretty much seen and experienced everything. And we work really closely with our colleagues on the helpline to assist customers with the legal problem that they might have.
Fantastic. Thank you all. So, as you can see, we've got a fabulous panel with me today, and I'm going to kick-start the conversation if I can and come to Jo first. So, Jo, could you talk to us a little bit about how you manage absence during someone's first few weeks and months within the organisation?
Yes, I can, yeah. So at Coveyor, we manage sickness absence consistently, so it doesn't really matter what somebody's length of service is. I suppose the only exception to that would be that we have an occupational sick pay benefit at Coveyor, and that doesn't start until someone's completed the probationary period. Like I say, we do have a policy, and that policy defines some quite clear trigger points at which we'd start to formally manage somebody's absence. And those are the things that give us the consistency around when we have meetings so that we can understand more about what's causing the absence. And they also give us an opportunity to understand whether the employee's got any needs or whether we should be making any adjustments to the working environment to help reduce the number of absences they have. So, like I say, it is about the consistency in how we manage sickness absence. And if any listeners after this would like to see our trigger points or the kind of the what point that we start to manage something formally, then I'd be happy to share that policy later on.
Oh, that's fantastic. Thank you, Jo. So, just heard a little bit there about how we manage it here at Coveyor, but I'd like to now pass the conversation over to Simon, first of all. Can you share with us a little bit of a wider perspective?
Sure. So when you take on an employee, usually you would have a probationary period, and this is your opportunity as an employer to assess the suitability of your employee in terms of their performance, whether they're settling in, and also their attendance. So whilst it is correct that you should treat everyone the same, there should be consistency across the board in terms of how you manage sickness, what trigger points you use, and so on. Probationary periods are there for a reason. It's there to check the suitability of the new employee, and something you should be taking into account is their sickness. You have to obviously factor in any disabilities and make reasonable adjustments for those, and so ensure that you're not discriminating against any of your new starters as you would for all your employees. But if you are thinking of ending someone's employment at the point that they're failing their probation. Really important that you take legal advice, even if you think you know what you're doing and you've been consistent. We're here to just check things off, rule out any risks, and let you know whether you are, relatively risk-free or low risk in terms of your actions.
Thank you, Simon. That's all really, really useful information. Kath, is there anything else that you would add on this point?
So I suppose the only thing I would add is a lot of the customers that I work with are quite frightened of managing sickness absence. And I think the key thing here is to say, make sure you are consistent, as Joanne has said, make sure you follow your policies and your trigger points. And as Simon has pointed out, really use that probationary period well to assess whether or not they're the right person for the role. And don't be afraid to consider termination in the probationary period if that's the right thing to do.
Fantastic, thank you. So the big thing that's coming out to me loud and clear there is that consistency in that process. Fantastic, thank you all so much. So Jo, I'm going to come back to you now. There's a lot of talk about mental health issues. Can you tell us a little bit about how someone can manage those scenarios?
Yes, I can. Yeah, so we do manage so at Coveyor, we manage mental health absences in a similar way to other types of absence, in that we apply our trigger points consistently from our policy. But if somebody does hit a trigger because of the frequency of absence or a length of absence, because often mental health related absence can be longer periods of time off work, we would meet with them and we'd try and seek to understand what's causing the absence, also what's causing them to need to be away from work. And we also try and understand whether we can make some changes to the environment to support them. So it's about what can we reasonably do to help somebody to be able to work effectively. And a couple of examples, so it might be giving flexibility around the working pattern, later start times, something like that, if that's something we're able to do. At Coveyor, we've also got an employee assistance programme as well, so we try and provide a holistic support to people. So that's giving access to professional support, so counselling, to help people to get the access to that quickly so that we can help them to feel well again. We've also got a wellbeing hub where we can signpost people to that if they need access to any further support as well. So it's kind of two-way, I suppose. One is managing the absence, but ultimately what we want to do is support people with mental health related illness to feel well again.
Fantastic, thank you. Simon and Kath, I can see you both nodding away there. So it feels like you're very much agreeing with some of the aspects there that Jo talked about. But Simon, is there anything else that you would want to add to that?
So yes, all responsible employers should be aware of mental health and should be aware that some employees will be suffering at any given time with either a long-term or a short-term mental health issue. Now, the key thing to remember here is that under the Equality Act, employees with a long-term health condition such as mental health would be classed as a disability, and we need to take care as an employer not to treat them less favourably or discriminate against them. And we're also obliged to make reasonable adjustments to assist that employee in the workplace. So it is a big matter to deal with, and we do speak to a lot of employers about how they manage mental health in the workplace. If you talk to us on the helpline, we can talk about some practical things that you can do. So one of the main benefits of the DAS policy is that all of our commercial customers have access to the counselling line, which you can give to your employees to use, and it's completely confidential. It's an outside organisation that we refer those employees to, and they can use that to get them through a difficult time. The counsellors are all trained to a level where they can assist someone through a short-term event, and hopefully that will be of great assistance to employers. Of course, if something is long-term and needs more thought, then please come back to us. We'll talk you through all the other options, including, OC Health referrals, and possibly going to the GP for some further guidance. But it's something we can't ignore, and if we ignore it and don't manage it correctly, then that can lead to some risk of a discrimination claim.
Thank you, Simon. That sounds like an amazing resource that's available on a very, very important topic. Kath, anything else that you would add?
Yeah, so I would add sort of what I've seen over the last 20 years is the reasons for absences have moved very swiftly from what we would call physical reasons, so back problems, so on and so forth, to mental health. So actually mental health is the main reason for absences in the workplace nowadays. And I actually think it's only going to increase as the awareness around it increases. One thing that I'm a mental health first aid trained. So I went on a course, a sort of certified course, and I've been called upon on quite a few occasions in the businesses that I've worked in to help those people when they're in crisis and be able to signpost them to areas where they can go and get support. So that's something a small business might want to think about, whilst they might not be able to afford like the EAP helpline, but obviously we've got the counselling available for them if they have a policy with us, is actually just training someone up within the organisation to be a mental health first aider. And then actually they've got somebody on site on support who can help if somebody is in a crisis.
Excellent. Thank you, Kath. Okay, so on a different topic now, I'm going to come back to Jo again first with this one. So thinking about ongoing illnesses, what happens if you've got one ongoing illness or perhaps a variety of different illnesses? Can you explain to us a little bit more about what we do?
Yes, it goes back to understanding where those trigger points are, and then about the manager then starting the formal absence review process and holding those meetings. Those meetings are there to understand what's causing the absence, whether that be an ongoing illness or whether it's a number of different illnesses. And sometimes this might also be an off-site meeting, so we might do it as a home visit if somebody's off sick for a longer period of time. Um, even meeting somewhere that is more comfortable for that person. So it really depends on the length of absence and what makes things easier for them. It's about getting to the bottom of what's causing the absence. And it's at this point that we look at whether these are related to one ongoing illness. And the other thing that Simon mentioned earlier, for us, it's about understanding whether the illness could be considered a disability, because that's something that we need to consider from a risk perspective as a business as well, to make sure that we're putting the right adjustments in place to support that person. We always talk to managers about making sure that we understand if there's any work adjustments that we can put in, because ultimately, like I said before, this is about helping the employee to be in work as much as possible, while supporting them through the illness, whether, like I say, whether that's an ongoing illness or whether there's a number of different things that are driving that.
So I think the key thing to think about here is how you want to manage absence and understanding how that impacts you as a business. For some businesses, it can mean the difference between delivering your services within regulatory obligations. For example, care homes need to have a certain number of members of staff present in order to deliver their service. So if you have a business where absence is key to you delivering your service, you might have slightly different trigger points, and as opposed to another business where it may not be as critical, but still needs to be managed all the same. One of the key benefits of having a DAS policy is that you have access to our DAS business law site, where you can build your own sickness policy. So there's lots of guides on there, videos to watch about what you as a business need in terms of managing your absence. And then there's a document builder at the end where you can create your own policy, and that ensures that it's right for you as a business, that it's managed consistently across your business, and that ensures that your outcomes are always going to be the same, obviously taking into account individual circumstances as well.
Thank you, Simon. Kath, is there anything else you would want to add on this one?
No, nothing to add other than to say, probably if I was advising a client at this point, and let's say somebody has been absent for lots of different reasons, there might be an underlying condition that are causing those things. So sometimes what I will do at this point is I will talk to my client about potentially referring to occupational health so that we can get an independent view on what's causing those illnesses and what we can do to support, which I think would happily lead into the next question, I think.
You were reading my mind, Kath. Okay. So people may have heard about occupational health, but Jo, can I come to you to tell us a little bit about how do we support people who are ill?
Yeah, so we use occupational health if we need further guidance from somebody who's medically trained to help us to give the right support to somebody who's unwell, whether that's a longer term illness or a number of different illnesses creating absence. They're really good at helping to suggest the adjustments that we might need to make. And also they can give us an indication of whether the illness could be considered a disability, so that's something we need to know about. And what the likelihood is of somebody being able to recover from that illness. So it's about getting somebody who's a medically trained professional to give us some more guidance to help us with our decision making.
Simon, Kath, from a DAS point of view, is there anything different, additional that you would want to add to this?
Yeah, I think the real benefit of using occupational health reports is that you can instruct them, telling them everything you want them to know about what the employee does. So, for example, you can detail what their working day looks like, what their working pattern is, whether that involves manual operations, whether that involves desk and so on. And I think, as opposed to the other option, which is just going to the GP for an opinion, by going to Oc Health, then you're probably going to get something a bit more tailored to your business, because you are giving over a lot of information about what your business does, what the employee does in their role, and they can give a more real beneficial opinion on what you can do as an employer to help them in their return to work.
Yeah, definitely. So I think I've worked with many commercial customers, and sometimes we will go to the GP and ask the GP to provide a report. What we tend to find is that the GPs don't really understand how they interact with their role at work, where occupational health providers do. So you tend to get that more tailored advice, really, really good recommendations around adjustments. Obviously, the duty as an employer is to make reasonable adjustments. So what the occupational health advisor will usually say is, I am making these recommendations, but it's for you as a business to decide whether or not they are reasonable. So that decision still sits with the employer, which is great. And I just find that it's a really good way to guide and allow the employee to have the opportunity to talk about how they feel they need to be supported as well.
Thank you. There's so much information and so much good ideas, great insight that you've shared already. But what I'd like to understand now, a really good way for our listeners to learn is understanding what are some of the common pitfalls to avoid. So, Jo, what are the most common mistakes that you see from managers in managing absence?
So I think Kath referred to this earlier. One of the pitfalls that I see in my experience is where managers ignore absence. Like I say, those conversations can be quite challenging, and ignoring persistent absence can then lead to bigger problems later on down the line. We do have a duty of care towards somebody, so it's for us to understand what's causing that. It's really, really important that managers use our policies and apply them consistently, because they're there to help us to prevent absences becoming bigger than they need to be. We also find that some managers find it uncomfortable to apply the policy guidance if they feel that an absence is genuine. I probably say how people describe it. The guidance is there, so the policy for us is there to manage genuine absence. That's what it's there for. It's there to support people who are unwell. We do have cases, or we have seen cases, where we might believe that absence is not genuine or not due to sickness, and there are other policies that we can use to manage that. So, for example, the disciplinary policy and process. What our advisory team do at Coveyor is we do meet really regularly with managers in the different business areas, and we try and work as part of a team, because what I find is if the managers are accessing guidance very early in the conversations or in somebody's absence, we can really help them to support them with problems before they become a lot more complex. So what we want to try and do is deal with those quickly.
That's great, thank you. Simon, do you see similar mistakes being made, or are there some different ones as well?
Indeed. When we talk to our commercial customers about managing absence, we'll often ask the question, have you done this before? What was the outcome last time? And if we've got inconsistency, so let's say we're looking at dismissing an employee for a long period of absence, and we ask the question, well, has anyone else been in this scenario? And they go, yes. And what was the outcome there? Well, we ignored it, or they're a really good worker, and therefore we've ignored it and we've not taken action. You can understand why you can get tribunal claims, and when you throw in discrimination and unfair dismissal, and you've got that inconsistency in a business, you can see why this can lead to some problems in terms of your outcomes. So I think the key message here is consistency. A policy is there to help all managers manage the absence in the same way. That way, that when you are needing to make a difficult decision, that is a real option that's available to you, and it's not something that you are going to do and think actually there is some risk here, and the risk of facing a tribunal claim can be real if you are inconsistent with your decisions.
Yeah, that consistency word again, I think it's been a common theme throughout the whole of this session. Kath, anything additional that you would want to add to this?
Yeah, so I think sort of picking up on the disability points, the hurdle for an employee to prove that they are disabled is actually quite low. So the legal test under the Equality Act is whether somebody has a physical or a mental impairment, that it's long term, so it has lasted or is likely to last more than 12 months, and it has a substantial and adverse effect upon their normal day-to-day activities. And I think where managers don't deal with the sickness absence and manage it, actually they're missing a sweet spot there, because the duty to make reasonable adjustments arises as soon as you're aware of the disability. So actually, if you've got somebody who is off on long-term sick or even these short-term persistent absences, you are likely at that point to have knowledge that the person is potentially disabled. So that duty to make reasonable adjustment kicks in. So it's really important to manage from an early stage to ensure that you're not failing to make reasonable adjustments, which is when that claim arises. I often get thrown at me from my commercial customers. They go, but the employee's disabled and we can't touch them. They've been off sick for 2 years, but we can't dismiss them because it's unfair. You can. And I think it just again comes back to, are you dealing with this consistently? Have you followed your policy? Have you sought medical advice? So it is just about making sure you follow that policy, and where you need it, you seek the advice from us.
Thank you, Kath. Simon, there's been a few times during the session today that we've talked about the helpline that's available through DAS, which sounds amazing and a great resource. At what point should someone really be using that helpline?
The legal advice helpline is there 24/7 for all of our policyholders. So I would say that as soon as your issue arises, please give us a ring. Even if you think you know what you're doing, it's always good just to run it by a lawyer, and then we can guide you through what your paths are. But more importantly, we'll talk about the risks involved with your path or your decision that you're looking to make. We're very used to it. We have quite a large team of employment lawyers who can guide you through those, what I see often some legal minefields. But there's a lot you can do at the start of your legal dispute that can send you off on the right track and the lowest risk route, as opposed to calling us at the point where you've made that decision. And usually when you've made your decision, the consequences are mainly what's the employee going to do, or the ex-employee, or the person discriminated against going to do next. So in terms of the helpline, it is 24/7. You can call us at any time. There's no limit to the usage. In fact, for the vast majority of our commercial clients, if you're going through a sickness absence process, that's going to involve a number of calls, and you can often speak to the same lawyer throughout that, and you can request them if you want to. No limit on the time, so we will not sort of say you've got 15 minutes and then we will we're not here to kind of push you off the phone or anything. We will just look to guide you through that process, and if it takes an hour, it takes an hour. If it takes longer, so be it. We'll also refer you to our online guides. So we've got lots of employment manuals with standard letters that you can use when you're guiding someone through a sickness management process leading up to a dismissal if you need to. We'll also have lots of guides and videos on how you manage each meeting or decision, so you're not on your own. And like I said, we're only a phone call away, and we're here to support you. For us, it's a success if you've managed to resolve your matter without actually getting to a stage where you're needing legal representation.
Excellent. It sounds like an absolutely amazing service. Thank you, Simon. Kath, if I can come to you with sort of the final question, and also it'd be great if you could summarise for us some of the key things you would like the audience to take away. So my final question, Kath, is what happens when it goes wrong?
Yeah, so sadly, this is where my team comes into play. So if it has gone wrong and the employee has initiated either ACAS early conciliation or a tribunal claim, that's where my team gets involved. So what you'd be looking at, let's say, for example, you have managed the sickness absence and sadly you've reached the point where you have terminated the employment. That is always on notice because it's not a gross misconduct dismissal. So you always have to terminate either by giving them notice and letting them work it or with pay in lieu. And then what would happen is you likely see a claim for unfair dismissal. And usually because the test for disability now is so low, there is usually a disability discrimination claim that accompanies the unfair dismissal claim. The typical disability discrimination claims we see are failure to make the reasonable adjustments. And then there's something called discrimination arising from disability. So to give you an example, if you have dismissed somebody because they've been on long-term absence and there's no likelihood of a return, then what you have done is you have dismissed them because of their absence, but their absence is related to their disability. So that's where that claim falls in. That is a justifiable claim. So if you have followed the policy and you have done everything you should have done in terms of trying to help them return to work and it's not been possible, then it's likely that you can defend that claim. If you get to the position where, let's say you haven't followed the policy, you haven't taken advice from us, and sadly a claim's been issued, what you're looking at is you've got your unfair dismissal compensation. So that's a basic award, the same as a statutory redundancy payment, and then a compensatory award of up to 1 year's gross pay, or if your gross pay is over £115,000, it's capped at £115,000. However, if there is discrimination then involved, that cap on the compensatory award is removed. So actually they can claim more than 115,000. And in addition to that, you would also have what's called an injury to feelings award. And those are assessed in line with a case called Vento. And we've got Vento bans. So for a one-off act of discrimination, the injury to feelings award could be between £1,200 and £11,700. If it's a more serious matter concerning discrimination, so there's been a few acts of discrimination, and this is where disability falls in, especially with failure to make reasonable adjustments, you're looking at an injury to feeling awards in the region of 11,200 to 35,200, so quite a wide bracket. And then for the very, very serious cases of discrimination, it goes from 35,200 up to 58,700. So it's not small change. I think that's the point I want to make. So I think following up on the themes, really, consistency, make sure you follow your policies, make sure you seek medical advice, make sure you do everything you can to support the employee. But don't be afraid that if you do get to the end of the road and there is nothing more you can do to support, know that you can make the decision to terminate if that's right for the business.
Thank you, Kath. So all there is left for me to say is massive thanks, first of all, to our fabulous panel today. Thank you to our audience and for your attention. And we really hope that you've enjoyed and found today's pod very, very informative, as I have. If you have, then please make sure that you subscribe to us on Spotify or follow us on LinkedIn, and that will make sure that you don't miss out on any of our fantastic episodes that we've got coming up. But also by subscribing, it will give you access to some of our older episodes, and we've got some really useful, interesting subjects in there, such as the rising cost of claims, the importance of supporting the needs of neurodivergent employees and customers, so some really, really good content on there. And finally, we'd also like to invite you to subscribe to our LinkedIn newsletter, because what that's going to do for you is bring you some monthly insight and horizon scanning updates from across the wider insurance industry. Thank you.